Hello students, today we will be talking about administration of justice and role of courts. Administration of justice can be termed as an essential function of a state. The present form of administration of justice has been reached at this stage by passing from various stages. Before coming into effect of the present legal system, people who wanted to get justice had to resort to private vengeance, being helped by friends and kin, as the state was not responsible for providing them with justice. But situation changed gradually with the formation of society and state. State took the responsibility of maintaining law and order in its most primary form of police state. Although the function of state has changed today as welfare state, still maintenance of law and order is primary work of the state. There might be cases where the courts have been criticized exceeding their jurisdiction. Whether it was justified or not could be debatable issue. The ruling in many public interest litigations to what we call PILs have done well to the society. Supreme Court of India is the custodian of the Indian Constitution while also being its interpreter and guardian. Parliament enjoys the authority to amend the Constitution. The Supreme Court has the authority to examine the validity of constitutional amendments. Judiciary is the final authority in interpreting legal issues and constitutional arrangements. Judge applies law to the facts, but the law is an abstract connotation which are not always simple, clear and unequivocal. It may not always be capable of providing a solution to the problem. There, the judge, by the help of techniques of interpretation, come out with a solution. Lord Denning versus Asher in Seaford Court Estates Limited has a very rightly observed, I'll quote, "It would certainly save the judges trouble if acts of parliament were drafted with divine prescience and perfect clarity. In the absence of it, when a defect appears, a judge cannot simply fold his hands and blame the draftsman. He must set to work on the constructive task of finding the intention of Parliament, and he must do this not only from the language of the statute, but also from a consideration of the social conditions which give rise to it and the mischief which it was passed to remedy, and then he must supplement the written word so as to give force and life to the intention of the legislature." Quotes closed. A judge should ask himself the question, how, if the makers of the act had themselves come across this rut in the texture of it, they would have straightened it out. He must then do so as they would have done. Quote closed. For a long time, the courts in India had an orthodox approach in interpreting the covert mandate of Parliament. administration of justice can be divided broadly into two parts. Number 1, civil justice. The rights which re-subject of civil proceedings are all civil wrongs. The term civil justice is used in different ways with overlapping meanings. Some authors use the term as synonym of the civil portion of the legal system as opposed to the body of law that makes up the criminal justice system. Others use civil justice to simply refer to civil litigation. Number 2, criminal justice. The wrongs which are the subject matter of criminal proceedings are called criminal wrongs. The aim of criminal justice is to punish the wrongdoer. Now, my lecture is in the context of the role of criminal courts in the administration of justice. Now, in order to understand the role of criminal courts in the administration of justice, let us divide the study into 5 components. Number 1, role of the court at the stage of investigation. A police officer is bound to register a first information report, which we famously call FIR, upon receiving any information relating to commission of a cognizable offence under section 154 of the Code of Criminal Procedure 1973. Now, any person aggrieved by the refusal of police to record the first information report can approach the magistrate. Section 156 clause 3 empowers the magistrate to order the concerned police station to register and investigate the crime. The power of the court to interfere with an investigation is limited. The court should not interfere in the matter at an initial stage in regard thereto. If it is found by the court that the investigation has been conducted by an investigative officer who did not have any territorial jurisdiction in the matter, the same should be transferred by him to the police station having the requisite jurisdiction. The power for remand and granting of bail rests again with the magistrate. The report of the investigation is also to be submitted to the court under section 173 of Criminal Procedure Code. Section 57 of the Code of Criminal Procedure provides that the arrested person shall be brought before the magistrate within 24 hours of the arrest. Number 2, role of court at the stage of inquiry. The stage of inquiry commences insofar as the court is concerned with the filing of the charge sheet and the consideration of the material collected by the prosecution, which is mentioned in the charge sheet for the purpose of trying the accused. Its purpose is to ascertain the truth or falsity of facts of the case. Every inquiry is conducted under this code by a magistrate or court. Now, if there is no case found against the person, it is for the magistrate to record it and discharge him. Before sending the person for trial or committing the case where the offence is triable by the sessions court, it shall be ensured by the magistrate that provision of section 207 of the Code of Criminal Procedure has been complied with. Now, number 3, role of the court at the stage of trial. Now, what does trial mean? Trial means determination of issues adjudging the guilt or the innocence of a person. In Narayanaswamy Naidu versus Unknown, the Madras High Court held that, and I quote, trial begins when the accused is charged and called on to answer, and then the question before the court is whether the accused is to be acquitted or convicted, and not whether the complaint is to be dismissed or the accused discharged. Quote closed. The Code of Criminal Procedure recognizes 4 distinct methods of procedure in the trial of criminal cases by magistrates, which are: number 1, the procedure prescribed for the trial of summons cases. Number 2, the procedure prescribed for the trial of warrant cases instituted on police reports. Number 3, the procedures prescribed for the trial of other warrant cases, and lastly, the procedure prescribed for summary trials. Now, trial generally it involves the following steps. Number 1, hearing of the accused before the framing of a charge against the accused. Number 2, framing of the charge. Now, charges framed by the court will be read over to the accused and ask them whether they are guilty. If the accused denies the guilt, plead innocence, then he will be sent for trial. Now, if accused pleads guilty, then no question of trial. Number 3, issue of summons to the witnesses for trial. Number 4, chief examination of witnesses by the public prosecutor. And number 5, cross examination by counsel for accused. Now, mandatory examination of the accused under section 313 clause 1 of the Code of Criminal Procedure 1973. Number 6, arguments by public prosecutor and defense counsel, and the last is judgment. It is needless to point out that the important role played by the court in these stages of the trial. Now, let me explain you some of the important provisions of the Code of Criminal Procedure reflecting the role of courts in the administration of justice. Now, according to section 310 clause 1 of Code of Criminal Procedure, any judge or magistrate may at any stage of an inquiry, trial or other proceeding, notice to the parties, visit and inspect any place in which an offence is alleged to have been committed, or any other place which it is in his opinion necessary to view for the purpose of properly appreciating the evidence given at such inquiry or trial. He shall without unnecessary delay record a memorandum of any relevant facts observed at such inspection. Now, judge's power to put questions or order production, the judge may, in order to discover or to obtain proper proof of relevant facts, ask any question he pleases in any form at any time of any witness or of the parties about any fact relevant or irrelevant, and may order the production of any document or thing. Power to summon material witness or examine person present. Section 311 of the Code of Criminal Procedure states, any court may at any stage of any inquiry, trial or other proceeding under this code summon any person as a witness or examine any person in attendance, though not summoned as a witness, or recall and re-examine any person already examined. Power to proceed against other persons appearing to be guilty of offence. Section 319 clause 1 states, where in the course of any inquiry into or trial of an offence, and if it appears from the evidence that any person not being the accused has committed any offence for which such persons could be tried together with the accused, the court may proceed against such person for the offence which he appears to have committed. Now, let us talk about appeal. Appeal is a scrutiny by superior court of an injustice or an error done by an inferior one, whose judgment or decision the appellate court is called upon to correct. The rule of law and judicial review is the basic feature of the Constitution. Now, let us talk about review. Human judgment at times may be fallible despite all the provisions for fair trial, and the just decision mistakes and errors may happen. So, the provisions for the review of judgment have been made. The position thus is that a criminal court has no power to review its own judgment when once it has been signed and pronounced. But a petition disposed of without hearing the opposite party can be reopened and reheard, because the power is inherent in the High Court that an erroneous act of the court done to the prejudice of one party can be remedied. The legislature, while wisely prohibited the subordinate courts from altering or reviewing their judgments, left the field clear to the High Court, because any error or mistake committed by the subordinate courts can be corrected by the High Court either by exercising its revisional powers or by exercising its power of superintendence under Article 227 of the Constitution. But such remedies are not available as against any errors or mistakes that may be committed by the High Court. Now, revision. What is revision? The object of revisional jurisdiction is to confer upon superior criminal courts a kind of paternal or supervisory jurisdiction. The idea is to correct miscarriage of justice which may arise from misconception of law or irregularity of procedure or neglect of proper precaution or apparent harassment of treatment and others like that. The object of conferring revisional power on the High Court and Sessions Court is to clothe the highest court in a state with the jurisdiction of general supervision and superintendence in order to correct grave failure or miscarriage of justice arising from erroneous or defective orders. Now, the High Court or any sessions judge may call for and examine the record of any proceeding before any inferior criminal court situate within its or his local jurisdiction for the purpose of satisfying itself or himself to the correctness, legality or propriety of any finding, sentence or order, recorded or passed, and as to the regularity of any proceedings of such inferior court, and may, when calling for such record, direct that the execution of any sentence or order be suspended, and if the accused is in confinement, then he be released on bail or on his own bond pending the examination of the record. Now, let me conclude by saying this, that judges have a great role in the administration of justice. It is needless to mention that the level of confidence the people have shown in the courts regarding the administration of justice. In Ramchandra versus State of Haryana, Justice O.P. Chinnappa Reddy in the said judgment says about the presiding judge in a criminal trial, and I quote, "If a criminal court is to be an effective instrument in dispensing justice, the presiding judge must cease to be a spectator and mere recording machine. He must become a participant in the trial by evincing the intelligent active interest, by putting questions to witnesses in order to ascertain the truth." Quote closed. It is the duty of a presiding judge to explore every avenue open to him in order to discover the truth and to advance the cause of justice. With that, we close today's class. Thank you very much.